Your Second Amendment existence can be terminated in exactly 24 hours. We are not discussing a jury trial, nor a guilty verdict rendered by peers. We are talking about a solitary communication to law enforcement that triggers a cascade of bureaucratic dominos. At this very moment, there are 6 specific legal detonators active within the American justice system that can strip your rights before you ever step foot inside a courtroom. If you remain ignorant of these mechanisms, you are standing on a trapdoor that leads to permanent disarmament. I am going to deconstruct the 6 hidden tripwires that liquidate gun ownership overnight. These are not criminal convictions. These are administrative maneuvers, civil restraining orders, and procedural loopholes that completely bypass the standard criminal justice architecture. By the conclusion of this briefing, you will possess the tactical knowledge required to identify these threats and the defensive maneuvers necessary to protect your liberty if you are targeted. Understand the gravity of the situation. This is occurring in real time across the nation. In the last 30 days alone, over 4,000 gun owners were separated from their property without ever being charged with a specific crime. The legal apparatus has engineered backdoors that nullify your rights instantly, and the vast majority of citizens remain oblivious until federal agents are standing on their front porch demanding the surrender of every firearm in their possession. We begin with the first mechanism: Emergency Restraining Orders. This is the vulnerability that catches the highest number of owners off guard. An individual, a spouse, a neighbor, a family member, can file for an emergency order against you. The moment a magistrate signs that document, a 24-hour clock begins ticking for you to surrender your entire armory. There is no hearing. There is no opportunity for you to present a defense. This is an ex parte order, issued solely based on one person's testimony, while you are completely absent from the room. We see this tactic deployed frequently during divorce proceedings, property disputes, and domestic arguments. The petitioner narrates their version of reality to the court, and if the judge perceives any potential threat, the order is issued immediately. The legal consequences are catastrophic. Under federal statute USC Section G, possessing a firearm while subject to this order is a federal felony carrying a sentence of up to 10 years in federal prison. The devastation lies in the timeline. You are stripped of your rights immediately, but you are not permitted to present your evidence until a full hearing occurs, which could be 2 weeks later. I have witnessed scenarios where a vindictive ex-spouse utilized a fabricated restraining order specifically as a tool for disarmament, and the tactic succeeded. The target lost their concealed carry permit, surrendered their firearms, and was forced to hemorrhage $15,000 in legal fees to eventually have the order dismissed months down the line. Your defensive protocol must be proactive. First, you must document every interaction during disputes with partners or neighbors. Texts, emails, and witness logs are your lifeline. Second, if you are served with an emergency order, compliance must be absolute and immediate. Do not attempt to conceal a backup weapon. That is a direct path to a federal felony charge. Third, you must retain counsel within the first 24 hours to prepare for the full hearing. While the temporary order is often automatic, the permanent order requires a burden of proof, and that hearing is your singular opportunity to reclaim your rights. However, there is a threat vector that is even more insidious because it requires no paperwork from an adversary. Number 2, mental health holds and involuntary commitments. If a law enforcement officer or a medical professional forms the opinion that you present a danger to yourself or others, they possess the authority to place you on a psychiatric hold. The second that event occurs, federal law prohibits you from owning firearms. This is not about a criminal conviction. This is about a 72-hour evaluation that can result in the permanent extinction of your Second Amendment rights. Consider this operational scenario. You are navigating a difficult divorce. You make a casual, frustrated comment to a friend about feeling depressed. They initiate a police wellness check. The responding officers determine you appear unstable and transport you to a facility for evaluation. Under the statutes of most states, that involuntary commitment is reported directly to the FBI's NICS database. You are now classified as a prohibited person under USC Section G. The fallout is life-altering. Even if you are released after 3 days with a clean bill of health, the record of commitment remains. You are barred from purchasing or possessing firearms. If you subsequently attempt to buy a gun and deny this event on Form RUR, you have committed perjury, a felony punishable by 5 years in federal prison. I have observed veterans lose their rights permanently simply because a VA physician reported them after they sought treatment for PTSD. You must exercise extreme discipline. Be incredibly precise in your communications with medical professionals and law enforcement. Statements regarding depression or anxiety can be the trigger for these holds. If you are subjected to a hold, demand a hearing immediately to challenge the commitment. Most jurisdictions provide a window of days for this challenge. Furthermore, you must understand your state's restoration mechanism. While some states offer a petition process to restore rights post-commitment, it is a labyrinthine and costly endeavor. The third mechanism is a trap that blindsides law-abiding owners who believe their past is behind them. Number 3. Old. Misdemeanor domestic violence convictions. You may have a misdemeanor on your record from 2 decades ago that has faded from memory. Perhaps it was a verbal altercation with a past partner where you accepted a plea deal to pay a fine and close the case. Here is the brutal reality. Under the Lautenberg Amendment, any misdemeanor domestic violence conviction, regardless of its age, creates a permanent federal prohibition on firearm ownership. There is no statute of limitations. There is no expiration date. This legal snare involves the boyfriend loophole closure, which has been expanded aggressively. The definition of domestic violence now encompasses former dating partners, not merely spouses. If you were involved in a physical altercation 25 years ago with someone you dated, even a minor shoving match, and were convicted of a misdemeanor involving force or threatened force, you are a prohibited person today. The penalty for possession in this category is draconian. Up to 10 years in federal prison and a $250,000 fine. This is particularly dangerous because many owners are unaware of their prohibited status until they attempt a retail purchase and are flagged by the NICS system. Panic ensues, and they attempt to liquidate their existing collection, but the trap has already snapped shut. Federal prosecutors can access records proving possession post-conviction, establishing grounds for multiple felony counts. Your only defense is total information awareness. First, retrieve your complete criminal history from every jurisdiction you have resided in. Ignored misdemeanors are fatal to your rights. Second, if a domestic violence conviction surfaces, consult a specialized attorney immediately regarding expungement or pardon. Certain states provide this pathway, which can restore federal eligibility. Third, never falsify form if your status is ambiguous. Secure a legal opinion before you ever attempt a transaction. What most gun owners fail to comprehend is that you do not require a criminal conviction for the next mechanism to completely destroy your rights. Number 4. Active substance abuse, specifically regarding marijuana, even in jurisdictions where it has been legalized. We must look closely at Question E on the federal form. The question explicitly asks, are you an unlawful user of or addicted to marijuana or any depressant, stimulant, narcotic drug, or any other controlled substance? Here is the federal trap. If you utilize marijuana, even if you reside in a state like Colorado where it is recreationally or medically legal, you are federally prohibited from owning firearms. Period. The Bureau of Alcohol, Tobacco, Firearms, and Explosives has made its stance explicitly clear and non-negotiable. Marijuana remains classified as a Schedule I controlled substance under federal law. Consequently, any use renders you a prohibited person under USC Section G. This is where law-abiding citizens walk into a felony. You hold a medical marijuana card. You believe you are compliant with state law. You enter a dealership to purchase a firearm. You are faced with Question E. If you answer no, because you rationalize that your medical prescription validates your usage, you have just committed perjury on a federal document, a felony offense. Conversely, if you answer yes truthfully, the dealer is legally mandated to deny the sale and record your admission. Now, the ATF possesses a record that you are attempting to acquire firearms while admitting to being a user of controlled substances. The consequences are not theoretical, they are catastrophic. Federal prosecutors are actively charging gun owners with felony possession after discovering marijuana and firearms within the same residence. It is irrelevant if the marijuana was purchased legally under state statutes. The federal penalty is up to 10 years in prison. I have reviewed case files where a gun owner was detained during a routine traffic stop for possessing a single marijuana gummy. Because that individual held a concealed carry permit and had a firearm in the vehicle, they were arrested for felony possession of a firearm by a prohibited person. The only defensive maneuver that guarantees legality is complete abstinence. If you use marijuana for any reason, medical, recreational, or therapeutic, you cannot legally own firearms under the current federal regime. Furthermore, if you possess a medical marijuana card, you should not possess firearms, even if you are not actively consuming the substance at that moment. The card itself creates a presumption of use. You must also understand that other substances can trigger this designation. Unprescribed Adderall or pain medications taken without a valid current prescription fall under this umbrella. Even CBD products containing trace amounts of THC can trigger this prohibition if law enforcement determines you fit the criteria of a user. But the landscape gets even more terrifying. The next trigger does not require you to commit a crime, lie on a form, or use drugs. It requires nothing more than an accusation. Number 5. Extreme Risk Protection Orders, colloquially known as red flag laws. Currently, 21 states have enacted these statutes. These laws empower family members, law enforcement officers, and in some jurisdictions, co-workers or school administrators, to petition a court to confiscate your firearms. The basis for this confiscation is not a criminal charge. It is not a conviction. It is based solely on a statement that you might be a danger. The terrifying reality of this legal mechanism is the lack of due process. No charges are filed. No crime has been committed. Just one person's testimony that they are concerned is sufficient for a judge to order the immediate seizure of every gun you own. These orders are granted ex parte. This is a critical legal term meaning from one party. You do not get to defend yourself. You are not present in the courtroom. There is no cross-examination of your accuser. A judge reviews the petition alone, and if they find probable cause, the order is issued. Within hours, law enforcement arrives at your doorstep. They demand the surrender of every firearm. If you refuse, you are arrested for contempt of court. The penalties for violating a red flag order are severe. In most states, possessing a firearm while subject to an ERPO is a felony offense carrying 1 to 5 years in prison. The nightmare does not end quickly. These orders typically last 6 months to a year. In some states, they can be renewed indefinitely if the petitioner simply files again. I have witnessed cases where family members utilized red flag laws as tactical weapons during custody disputes or inheritance battles. They file petitions with fabricated claims specifically to disarm and discredit someone they hold a grudge against. Your protection requires immediate and decisive legal action. First, if you are served with an ERPO, you must completely surrender all firearms to law enforcement or a licensed dealer within the specified time frame, which is usually 24 hours. Do not attempt to hold anything back. Second, hire an attorney immediately. You must prepare for the full hearing, which typically occurs within 14 days. This hearing is your only opportunity to present evidence, call witnesses, and prove you are not a threat. Third, document everything that led to the order. Texts, emails, and witness statements are critical because false accusations can be challenged, but you cannot win without evidence. The final trigger is the one that catches the most gun owners by surprise because it often arrives through the mail. Number 6. Federal Indictments. Your gun rights vanish the moment you are indicted, not when you are convicted. This is a distinction that destroys lives. Under USC Section N, if a federal grand jury indicts you for any crime punishable by more than 1 year in prison, you are immediately prohibited from possessing firearms or ammunition. This prohibition activates before your trial. Even if you are innocent, and even if the charges are eventually dismissed, the indictment itself triggers the prohibition. Federal investigators build these cases in silence. You might not even know you are under investigation. Then one day, a grand jury issues a true bill. Within hours, federal agents are executing a search warrant to seize every firearm in your home. You haven't been convicted of anything. You haven't had your day in court. Yet, your Second Amendment rights are suspended indefinitely. The consequences of violating this provision are crushing. If you possess firearms after an indictment is handed down, that is a separate federal felony under USC Section G, carrying up to 10 years in prison. Here is the trap. Many gun owners do not immediately surrender their firearms after an indictment because they operate under the assumption that they are innocent until proven guilty. That assumption is fatal here. Federal prosecutors will simply add firearm possession charges on top of the original indictment. Now you are facing decades in prison instead of years. Your protection starts the moment you even suspect you are under investigation. First, if federal agents contact you or execute a search warrant, hire a criminal defense attorney immediately. Do not wait for the indictment to drop. Second, if you are indicted, surrender all firearms within 24 hours to law enforcement, or transfer them to a family member who is legally allowed to possess them. Do not keep even one for protection. Third, Understand that these prohibitions remain in effect until your case is fully resolved. If you are acquitted or charges are dismissed, you can petition to have your rights restored. But attempting to possess firearms during the legal process is a separate felony. Let us recap the 6 legal triggers that can end your gun rights overnight without a trial or conviction. 1. Emergency Restraining Orders. 24 hours to surrender all firearms based on ex parte testimony. 2. Mental health holds and involuntary commitments. A 72-hour evaluation can permanently prohibit you. 3. Old misdemeanor domestic violence convictions. No statute of limitations. Permanent prohibition. 4. Active substance abuse, including marijuana. Even legal state use triggers federal prohibition. 5. Extreme risk protection orders. Red flag laws allow confiscation based on unproven claims. 6. Federal Indictments. Prohibition begins the moment you are indicted, not convicted. Any one of these triggers can cost you thousands in legal fees, your freedom, and your right to own firearms forever, all without ever being convicted of a crime in a courtroom. Do not let confusion about gun laws put you at risk. Subscribe to Guns Law Guide so you never miss an update that could keep you legal and protected. I break down complex gun laws every week so you can carry with confidence and avoid the legal traps that destroy gun owners just like you. In the next video, I am covering the 9 gun purchasing mistakes that cost first-time buyers their freedom, including the one error on your form that triggers an immediate FBI investigation. You will not want to miss it.